Hello everyone, we are going to go over laws and regulation policies today, so let's get this started. The purpose of laws and regulations is really to ensure that providers are competent and we're protecting the public. We want to make sure that we're doing what's right for our patients and for the profession itself. We want to ensure that the taxpayer dollars are being spent appropriately. It does create a scope of practice for our therapists and distinguishes us from other professions, provides us with our license, and then receive rights and protections along with these other options. Keep in mind that all of these are going to vary state to state. This chapter really is focused on just the general principles about laws and regulations and how they look. It's a broad chapter because we're not going to go into each law and regulation for PA. That would take forever. And then also for every other state, it would just take too long. The aspects of practice may be governed by state and federal law, and some laws affect reimbursement. So you can technically do it, but insurance just may not pay for it. So that's why I have here services not reimbursed. It doesn't mean that the service can't be provided. If you feel like your patient would benefit from iontophoresis, you can do it, but that doesn't mean that the insurance is necessarily going to pay for it. So a law is defined as a body of rules of action or conduct prescribed by the controlling authority and having binding legal force. These are created by legislators, courts, or governing agencies, and the three main areas are criminal, civil, and contract, and we're going to go over each one in the next few chapters. So criminal law is acts done in violation of those duties which an individual owes to the community. These are crimes that are typically committed against society. So you're stealing, breaking and entering, disorderly conduct. Those crimes can be done against someone else, but you are breaking a law against the society, and the society rules need to be upheld. This is prosecuted by the state on behalf of the public, and any consequences include fines, probation, and imprisonment. Typically, criminal prosecution will lead to referral to a state disciplinary agency. This is different per state. Depending on what the crime is, will depend on what the prosecution is and so forth. So civil law is concerned with private wrongs and remedies. If you guys have ever seen Judge Judy or Hot Bench, this is where you're going to see your civil law actually happening. This is where one citizen brings a lawsuit against another, usually to seek compensation for injuries received or for a job not done. Typically, the consequence is to pay monetary damages to the plaintiff, just mostly dealing with money is where this is happening. In civil law, you cannot be fined or jailed. The most common ground for civil actions against a PT or PTA are negligence and malpractice. This can also have defamation as well. So defamation is saying or writing something untrue that harms another reputation. I actually had dealt with civil law once before when I had hired someone to do my roof, paid them the deposit to come, and then they never came. So they had basically stolen, so I was doing a civil and a criminal suit to get that money back. Negligence. We're going to talk about negligence and malpractice and what the difference is. So negligence is a failure to act as a reasonable, prudent person. So an example here is a failure to mop up spilled water in the clinic with someone subsequently slipping and then hurting themselves because they slipped on the spilled water. What it describes is that a normal, reasonable person would have recognized that that spilled water was going to pose a risk of injury and would have mopped it up. So then malpractice is professional negligence. This is a failure to do what a reasonable, prudent member of that profession would have done that caused injury to the patient. So here an example would be that the therapist would excessively mobilize a joint and then it causes injury, where you as a professional would know that mobilizing the joint too much could cause that injury. So when we're looking at the two, negligence is just the failure to act as a prudent person. Professional negligence is having to do with your profession and doing something that you know shouldn't have been done, because as a therapist, you should know that that would cause injury. Vicarious liability, which is the ultimate responsibility for patient care, remains with the PT. You can be treating a patient for a long time, and they could be on your schedule the whole time, but that ultimate responsibility will fall with your PT. And the PT's duty to patient to make good and decisions and delegate appropriately. PTA students and aides can be held legally liable for their own negligence. However, the therapist may also be liable if the tasks were negligently delegated or supervised. An employer can technically be negligent as well. So risk management is efforts of organization to identify, assess, and minimize, where possible, the risk of suffering harm or loss to patients, visitors, staff, and the organization. So this really is your job as a profession to decrease the risk of lawsuits, and constantly monitoring that quality of service. At Select, they had constant chart reviews between the clinicians and clinics, constant staff meetings to review what you were doing with your patients or what you were doing at the profession itself. So you would have a PT from Harrisburg go to Lancaster, and they would flip-flop, and they would review each other's charts to make sure that we are doing everything that we can with our patients, but also documenting it correctly and billing it correctly. This will decrease that risk of the lawsuits and help monitor the service that we are actually providing at the clinic. You will carry professional liability insurance. You'll actually have this when you go out into the field as a student. You'll purchase it. This will not cover legal fees for professional misconduct or criminal actions, but you will purchase it for yourself as a student, and then when you go to your clinic should actually be providing this. I should say typically, not all the time. Typically, your clinic will provide that for you. So contracts, there will be lots of different contracts. I'm sure you guys at your age, you may have already signed one by now, but it is agreement between two or more persons, which creates mutual obligations to do or not do particular things. Technically, which I'm not going to really go into this, but technically in the state of PA, you can have a verbal contract and that's legally binding. But we're not going to talk about that with therapy. This is a matter of civil law and can be enforced in court. Some examples in therapy that you might find is employment contracts, contracts with independent agencies, contracts with managed care organizations to become recognized providers and be reimbursed for their services. You can also have contracts with so independent agencies. If we're looking at that, we can have contracts with WorkNet. So workers' comp patients that come in and have injuries, I am contracted with them to treat their patients. You can also have affiliation contracts. So I deal with affiliation contracts all the time. I reach out to my clinics. They have to agree that they're going to take on their student and be the best teacher that they can be. And that's a legally binding contract. Statutes is a type of law that is enacted and established by the will of the legislative department and government. Most statutes affected by PT may be passed by federal level. There can be federal or state statutes, and they can all be enforced at these levels as well. So we're going to break those down a little bit. Federal statutes apply to all citizens across all state lines. This is supersede the state law. So the things that we're talking about with this is Americans with Disabilities Act, the ADA. We just talked about some of these. Individuals with Disabilities Education Act, Social Security Act, Medicare program, and also HIPAA, which, do you guys know what HIPAA stands for? You're going to need to know this. Health, Insurance, Portability, and Accountability Act. So again, that's Health, Insurance, Portability, and Accountability Act. All of these are federal statutes. That goes to all citizens all over. These consequences, if you do not abide by them, can be fines, injunctions, and court orders. So an example would be fraudulent billing to Medicare. You're billing Medicare too much. That could be jail time fines, and also you could technically lose your license. State statutes for state regulated areas with no superseding federal law exist. This is where your State Practice Act is going to fall, and that is the legal foundation of the scope and protection of your PT practice. The State Practice Act, again, just like it is in the title, is going to vary per state that you are going to. This defines your definition of a PT practice, identification of providers, identification of tasks that may be delegated and to whom, and supervisory requirements. This State Practice Act says what, as a PTA, we can do in the state of PA. The Practice Act is the final word regarding what is legal in the PT practice. In some states, if you are not following by this, it can be considered a criminal act. So make sure that you are understanding of this and what you can and can't do. The MPA, or the Model Practice Act for Physical Therapy, was developed by the FSBPT. This is also they are also responsible for the national exam. This Model Practice Act is not enforced by law, but it is intended to be the preeminent standard and most effective tool available for revising and modernizing physical therapy practice acts. So when we're talking about this, that some states will technically take this MPA and use it to revise it to how they like it. It's technically just a template, but it is intended to model what you should be doing during your practice. All right, so differences in State Practice Act. We talked a little bit about this, but this is a little bit more of a more detailed list. Direct access, it is legal in all 50 states, but the rules are different depending on where you go. Joint mobilizations, continuing education requirements, the level of supervision, requirement of license for PTA, and tasks that can be delegated. There's also sharp debridement, dry needling. That's just a small difference of how the Practice Act can be different from state to state. So licensure and certification, this creates the scope of practice and authorizes that individual to actually practice and provide therapy in that state. This legally protects the title of a PT or PTA. Only licensed individuals may refer to themselves as such. You cannot say that you are a PTA until you have a license that says you are a PTA. This is one thing that I have. It's just a little pet peeve, I guess you would say, is I've had some students list themselves on their Facebook as a PTA, or I've heard them say they're a PTA, but I know that they're not licensed yet. You cannot refer to yourself as a PTA unless you have that license. And once you have that license, you're going to feel that you've earned it and that you've earned that title, and you're going to want to protect that title for yourself. PTA regulation, you can have a licensure, certificate, or registration. I have not found a state with a certification or registration. Now, I haven't done a ton of research on all 50 states. I don't have time, but the states that I have been working with, I've noticed that it is just a licensure. A licensure protects the title of PTA and designates a scope of practice. A certification protects the title, but there's no separate scope of practice and may or may not have to pass the licensure exam. And registration is the least rigorous form of regulation, and this requires registrants to provide state with updated information on name, address, and qualifications, which doesn't seem like nearly enough to provide yourself with a PTA title. But again, it varies per state. Regulations are developed by government agencies, not legislature. It is a rule controlling the practices of individuals or organizations under control of an agency. And this can include regulation of industries and government benefit programs like Medicare and Medicaid. Agencies created by statutes and overseen by legislators, and regulations enforced within certain industry program. So really, the take home from this slide is statutes are vague and regulations provide more detail to that. There are federal regulations from a federal agency that greatly impacts PT is the CMS, or Center for Medicare and Medicaid Services. This is under the U.S. Department of Health and Human Services. This is important. They determine what extent therapists may participate as providers and how much and for what services they will be reimbursed. So who can treat and what we can bill for. Medicare really likes one-on-one practices. They also have 4 different parts to their regulation, part A, B, C, and D. So you should understand which each part does. We're not going to go into that. That's too much detail for this class, but you'll get into a little bit more detail later on in the coursework. Medicare regulations is a failure to abide by Medicare regulations and can result in denial of reimbursement, which is the last thing that you want to happen for your clinic. It's so important, and I'm sure you've heard of incorrect billing. We just don't want that to happen. Fines and criminal prosecution can happen, but it is a bad rap for your clinic, and that's the last thing that you want to happen for your office. State regulations. We have a state board of physical therapy here in PA. Actually, Dr. Wolf works for our state board. She is the VPAA of the college. You can see the state board at ppta.org. This advised legislator to clarify the scope of practice that provided advance to state licensure practitioners seeking guidance on practice issues in that state, administer their licensing procedures for the state, and consulted by prosecutors in misconduct cases. Our State Practice Act is sometimes difficult to work with. They don't always get back to you right away, which is frustrating, but they have always been really good at answering any of my questions that I have about practicing. So professional misconduct, which was just stated in the slide above, is an action that demonstrates an inability to competently perform the duties of a licensed professional. So actions that are defined in our Practice Act of professional misconduct are physical sexual abuse of a patient, patient abandonment, improper delegation, providing unnecessary treatment, fraud, incompetence, and practicing while intoxicated. I think that you'll find that a lot of these were found in our ethics, our PTA ethical conduct. It's the same thing. So creating statutes and regulations, these therapists and assistants must remain aware of and be in compliance with laws. They are constantly changing, so we need to make sure that we understand who we can treat, when we can treat, how laws are made. They are introduced proposed statute bill to a house of a legislator, assigned to a committee to collect more information. That committee's bill is then sent to the floor for debate. If it is passed by the House, then they're sent to another to undergo that same process. And after passing in both houses, it is sent to the president or governor to be signed into a law or vetoed. It is a lengthy process. It takes a long time, but our APTA really does a good job about lobbying to lawmakers about what is important for our field. That's why the APTA is an important aspect. Again, these procedures can vary from I know I keep saying that, but a lot of things can vary from state to state. Typically, it's about the same, but some things might be a little bit different. An agency must publish proposed regulation and give interested parties time to comment. We need to make sure that we are proposing it to them. They can comment on whether they think it's going to be good or not and lobby for it or not for it. This gives us really a lot of time to educate these bodies on why we need this to happen. Common law is a law that has been created by court decisions, written by judges, and handed down. They modify or overrule existing decisions, and negligence governed primarily by the common law. Malpractice and negligence are both. So policies. How many of you guys have had a policies and procedures manual at your clinic? It's huge. This is a decision which obligates actions or subsequent decisions on similar matters. Sometimes these are defined by the ATA. Sometimes they are just set by the organization. Procedures are actions required to implement policies, and these policies can be set by any one of these people: organizations, employers, or payers. So you're going to find that your Dreyer Physical Therapy will have a policies manual, along with Highmark Blue Shield, who you're billing to, or to WorkNet, who you have a contract with. There are lots of different policies that you're going to be following. These cannot be legally enforced unless it was set with a contract. Sometimes when you get a job, you sign a paper that says you are agreeing to the policies and procedures manual and that you will follow them. Now they are set in and binding by that contract. APTA has policies, but they are a private organization. These policies are only binding to the members themselves. More information can be found on the website, and this really affects and drives the changes in the practice. But again, the APTA policies are only upheld they are only binding to the members themselves. Violations of APTA policies or ethical standards are first reported to a state chapter president. So in PA, it would go to the PA state chapter president. The ethics committee would begin an investigation. The member who was accused or the therapist who was accused would have an opportunity to respond about what had happened. And after that investigation, a complaint referred to national organization if there was merit. Payer reimbursement policies. So these are your insurance payers. Those insurance payers will determine who can be a provider, what services will be reimbursed, how much they will reimburse, any documentation requirements to get that reimbursement, and procedures for claims review and appeals for a claims denial. There is no way that you're going to remember or memorize every single one of the payer reimbursement policies. Not possible. But that's why you work together with your clinician, your PT, other clinicians in the clinic, and your secretary. They will all understand those as well and help guide you through. So recent changes in reimbursement is creating dilemmas and allowing reimbursement to drive the practice. We, as providers, must educate payers to ensure reimbursement is adequate to meet the patient needs and why the patient needs what they do. So that's why your documentation is so important. We also must advocate for our patients, and that's why the evidence-based practice, what we're doing, why we're doing it, is important, because it shows the payers that these are things that our patient needs. If we are not active in this or doing what we can, it's not necessary that you need to be a member of the APTA, but just trying to drive your field to where it needs to go. Employer policies. Facilities develop specific policies and procedures, including your job description, intervention protocols, documentation requirements, and safety issues are all a list of what you might find in your policies and procedures manual. There's a standards of practice require facilities to have written policies and procedures to ensure that what you're doing is the highest quality physical therapy that you can give to your patients. These are created by the employer, so they will be provided by Select, by Dreyer, by CPRS. They will all have their own policies. They can be, they cannot be technically enforced unless part of an employment contract. I think that you will find that those are more common, that you are signing a contract to abide by these policies. It can be grounds for disciplinary action or termination. Refer to whatever facility you are at in their manuals in any malpractice or negligence cases. And then you should not follow these blindly. Make sure that you understand what they are calling for, what is ethical, legal, and effective for your patient care. Again, there's no way I could read through an entire policies and procedures manual. I would fall asleep. It is long, but you need to understand the most practice that you can. Now, there is a case study here. We are not doing that, so do not worry about it. That is it for today. If you guys have any questions about the material, please let me know. Otherwise, we will talk soon for the next chapter.